May it please the Court, I'm Joshua Gordon. I represent Bill Hogan sitting here. I'd like to turn to Davis's discussion of damages, and he has good reason to be concerned about them because his client was a major player in this drama. Mr. Wood started the company, which was named after his boyhood nickname, and took Syncom's customers. Bill Hogan played, at most, a bit part. Bill Hogan's job at Syncom was ministerial. As the Court said, cleaning business is not brain surgery. He came to Syncom with years of experience at estimating pricing in the commercial cleaning industry. He came to Syncom as something of an expert in production rates. That's the amount of time it takes to accomplish a particular cleaning task. And this expertise is what he was hired for. But at Syncom, his job was limited. He traveled to movie theaters, he measured square footage, and counted the number of seats, toilets, escalators, and windows, things that needed cleaning. He applied these production rates to those items, then sent the information to the corporate offices here in New Hampshire where Mr. Sinopoli did the estimates for his sales staff. The other half of Mr. Hogan's job was lining up subcontractors to do the actual cleaning. Hogan was not in sales. His contact with customers, theater managers, was generally an hour or two appointment to do the measuring and later hearing about any problems there might have been with cleaning subcontractors. Mr. Hogan did not enjoy any special trust or special confidence, had no special relationship with Mr. Sinopoli, no control over proprietary information, and he is not a fiduciary. Now, I want to talk about the 4 non-compete covenants, which are in my brief at page 4. The first 2 of them, which apply during employment, were not violated by Mr. Hogan. The court below found that Mr. Hogan was not involved with Big E during his employment with Syncom, and that's the plaintiff's findings at paragraph 39. And the evidence shows that any documents that Hogan might have supplied to Wood were in March 2002, that date's important, several weeks after he was fired. Covenant number 3 doesn't...
Aren't they still confidential information, though?
There's nothing on them that's confidential.
Didn't the court find otherwise?
The court found otherwise. Covenant 3 does not apply to Hogan because he was not in sales. Non-compete covenants must be reasonably related to the employer's legitimate interests. Hogan had very limited contact with theater customers. His job was to count urinals and hire subcontractors.
Mr. Gordon, can I ask you, on these issues, and going back to Justice Hick's question, aren't these factual findings? I mean, where's the legal error?
Well, I think the court looked at what he divulged and called them secrets, but they're not. Anything that Hogan told Wood about production rates, he knew from 15 years of experience in the cleaning industry.
Let me ask you, on that point, just stop the film right there.
Sure.
Isn't that a factual finding?
Factual finding.
So we have to say what? Unsustainable exercise of discretion?
It is. Look at them. They're Exhibit 31. He didn't learn any of this stuff at 4.5 months at Syncom. He was hired for his understanding of how this stuff happened and what's supposed to be counted and his knowledge of how each component of the cleaning job. There's nothing confidential about how he counted at theaters. Anyone who buys a ticket at these theaters can go in and look at how many screens and seats it has, and the information is readily available on public websites. The theaters publicize this stuff.
Isn't it true that the court found that he was taking customers away from the plaintiff?
The court found that he was taking the court found that he had a role in taking customers away from the plaintiff.
I mean, it was not just the documents that were revealed later, but it was the actual taking away of customers that was the problem, wasn't it?
Well, 2 things. In his testimony, Sinopoli could not identify a single secret that Hogan took. He also couldn't identify a single client that Hogan took. He identified plenty that Wood took. But even if he took these secrets, it's too late to cause any damages. Because Mr. Wood set up his company, Big E, in mid-January and took Syncom's customers within a week. And the Exhibit 31, repeatedly paraded during trial, there are faxes from Hogan to Wood containing the production rates for these individual theaters. But they're dated in March, a month after Hogan was fired, 2 months after Wood had already successfully made these bids on the theaters, successfully procured them as customers, taken them from Syncom, and even had gotten paid on some of those accounts. So even if Hogan did everything that the court found he did, he didn't participate in the damages that Syncom suffered. So if there are damages, they're not caused by my client Hogan. They're caused by Wood. The wrap-up is, if you take Wood out of the picture, there's no damages. If he takes Hogan out of the picture, Syncom suffered exactly the same damages. My client is not liable. Finally, Hogan had no malicious animus. It was Wood who wanted to destroy, and that's his words, Syncom and Sinopoly. Syncom's testimony is all about Wood's action. Read Sinopoly's testimony. It's about Wood, Wood, Wood. He makes clear that it's Wood who invented the scheme, who lined up the financing, who established the competing company, who raided Syncom's senior management staff, and took its customers.
So Mr. Hogan on this record was just kind of an innocent bystander. Didn't know, wasn't involved.
Well, like the court said, he was a follower, not a leader, and he went along. Wood is obviously a strong personality. He had this health insurance anger sort of boiling in the background, and he said, and he sort of did what Wood told him to do. Whether Wood was malicious or wanton or oppressive, Hogan wasn't. He had no such animus and should not be tagged with Wood's motive. Accordingly, he's not liable for any damages and certainly not enhanced damages. There's no questions. I'll sit.
Thank you.